Hi, Anil. We can start the webinar.
I was going to ask, are you going to make any introductions or should I just get started right away?
You can get started right away.
Great, thank you. It's great to be here and thank you, our partners, IVCA, Sunita and Shreya. Thanks for helping organize this on this. I've been sitting in Gurgaon, so hot afternoon, and others on the phone. Thank you for joining. We have a very interesting, at least what we believe is a very interesting and very relevant subject, cross-border India-US investments. I'm going to be taking a very short sort of quick introduction to Inventors Law, the law firm myself, and my partner Ashita will walk us through the one area we've developed, which is very useful for India investors that are investing in cross-border structures. In terms of introduction, my name is Anil Advani. I'm the founder and managing partner of Inventors Law. We are a Silicon Valley-based law firm, and we work with, I would say, hundreds and thousands of startup founders, angels, investors, primarily for the last 20, 21 years, primarily in Silicon Valley, the typical sort of Silicon Valley structures. But in 2009, I saw the emergence of the cross-border India-US opportunity. And like any other good entrepreneur, I decided to invest more resources. And in partnership with Ashita and our team now in India, we've developed what I would at least call our leading expertise in both India, US, and structuring these transactions, which thankfully and at the same time has become very hot and a very significant part of our practice. One of the things that we help, I spend 50% of my time, or we spend 50% of our time helping Indian founders incorporate or reincorporate and flip their existing structures or create new structures. Indian founders sitting in India, incorporating, reincorporating into Delaware holding companies. The primary purpose of that is so that they can smell, walk, talk like any other Silicon Valley company, really present themselves as global technology companies, be able to work with customers across the world, protect. Delaware does provide, and US laws generally provide, and certainly the perceptions they provide, much better protection for intellectual property. You can file patents for software and some others, copyright, trademarks. All of that is very easy and well established. The venture capital community, the private equity community in the US has been 50, 60, 100 years old. So there's lots of precedent, legal, tax, structuring. So founders sitting in India can take advantage of that, and we certainly help facilitate that. So that's certainly a leading part of our practice. And as I'm sure I don't need to preach to the choir here, that is a number of Indian companies have done really well on the global scale as US holding companies. I expect, and I think we all expect, and this is why we're on this call, that trend will only continue. We will see tens and hundreds of companies get listed or become large global sort of businesses with, again, founders sitting or starting from India. The technology being built in India, but for the world. And we've done, and we'll continue to invest a lot of time as needed to help facilitate that transactions. So that's the background of who I am, what Inventors Law does. I'm going to hand it over to Ashita Bhagwan, who heads our Inventors Law India. And she's been actually instrumental in creating structures that allow Indian investors that are, for other various reasons, not able to or not able to yet mostly invest in US companies directly, not miss out on the opportunity. So they can still be participate in the emerging opportunity by investing in India, while continuing to get the potential upside of the large sort of opportunity, as I call it, emerging in the India-US space. So without much further ado, and I'll hand it over to the star of the evening, Ashita, to walk us through the presentation.
Thank you so much, Anil. That's a very generous introduction. Good afternoon, everybody. Thank you so much for tuning in. As Anil said, I'm Ashita Bhagwan. I'm a dual licensed corporate attorney, and I've spent about a decade in the US practicing corporate law, mostly on the West Coast. And I moved to India about 5 years ago, and as part of the move, also set up Inventors Law India, and we focus on cross-border transactions and being available to the entire VC community in India on the same time zone. So they can reach out to people who have experience both on the US side and on the India side. And as Anil mentioned, one of the primary focuses for our practice here has really been the development of the shadow structure, which allows Indian investors to participate in non-India companies' financing rounds without having to go through the SEBI approval or the LRS route or any approval process. And we'll go through the specifics of this in the presentation today. And Shreya, if you could please cue that up, that would be really great. We will talk about how an Indian investor can invest in a US-India company without having to directly invest in the US company. Instead, what we see is that the investment can be made into the subsidiary of the US company, but then the goal of the structure is to put them in the same position that they would have been had they been able to invest in the US company directly. And we achieve that through a number of ways, which we will discuss on this call today. And I have received some questions as well prior to the presentation, so I'll try to hit upon that as we go through the presentation today. Shreya, can we get started with the next page, please? So this gives us a little bit of background. As we all know, a lot of our Indian investors are restricted in their ability to be able to invest in non-India companies which have step-down subsidiaries or non-India companies. It's not that you cannot invest, but it's just that you need either approval, prior approval, and there are limits based on which you can invest in a financial year, etc. I don't have to go into the specifics of that, but we do know that there is a little bit of a hurdle for any Indian investor, whether it's an AIF, whether it's an HNI, whether it's a family office, whether it's just an individual who wants to invest, there's still an LRS cap of about 50,000. So we see a lot of this happening, but what happens as a consequence of that is that our Indian investors are obviously potentially missing out. I don't say they will miss out, but they're potentially missing out on the opportunity to be able to participate in these, multiple unicorns that are sprouting up every now and then. So what we did a few years back was we created this structure which allows our Indian investors to be able to invest in the non-India company without having to actually transfer money overseas. So the idea is that the entity has a US parent company or a Singapore or any other holdco that is in existence. And that entity has a subsidiary in India. Now, the moment you have a subsidiary in India, it opens up a lot of doors for us because there is an entity in India into which we can put money. So what we do as counsel for the investors is to present the option for the investors to invest into the company. So essentially, you agree commercially that these are the terms, etc., and you invest into the subsidiary of the US company. And in exchange for that, you will actually get CCPS in the Indian company. So that makes you a shareholder, number one. The second thing that we do as a part of that is that you are given 2 levels of protection here. One is that you get a put option, and the put option will essentially allow you to get exit proceeds from this group structure at the time of the exit, but you will receive that exit in India. So you don't have to worry about swapping shares. You don't have to worry about money having to come from there to here, none of those things, right? All that you need to do is you will invest money into the subsidiary in India and you will get shares in exchange for that. And along with those shares, you will get 2 things. One is the put option that I was just telling you about. The second thing is the contractual rights that you will negotiate with the startup or the investee company. Now, these contractual rights are just like any other investment that you would have made. Even if you had invested in the private limited company, you would have gone ahead and negotiated these rights. So we will still give you these rights. And at the end of this structure that we have created, you will end up having invested in the India company and you will get shares in the India company. So you do become a shareholder. And the second thing is you will get a contractual right for a put option when there is an exit at the US company, and B, for contractual rights that you have negotiated as part of your commercial agreement. Can we go to the next slide, Shreya, please? Yeah, so I'll talk to you a little bit about the different steps involved in this process, and that would hopefully answer some of the questions that have come up or that you might be thinking about. The first thing, of course, is to make an investment in the India subsidiary. So the way that this will work is that the India subsidiary goes through a process of receiving the amount here. We can do a private placement, a rights issue, whatever it is that is ideal at that point of time. But essentially, the Indian subsidiary receives the funds And in exchange for the funds that they receive, they will issue CCPS. Now, CCPS is the preferred security, but we've also done this with CCDs. We've done this with equity shares. We've done this with OCRPS. So there's a number of securities that can be used as a part of this. The idea is that you get shares in the India subsidiary in exchange for the CCPS that has been issued by the India subsidiary. So that's step one. Can we go to the next slide, please, Shreya? Now, step two is really negotiating all of the other rights, right? And I won't go into the negotiation because that's very, very deal specific. But what you should know is that what you get along with the put option, which we will also discuss in a little bit, is a number of contractual rights that we will have the US company a party to as well. So we will come up with one shareholders agreement, and the shareholders agreement will have the Indian subsidiary, which is a party because you have received shares in the Indian subsidiary, will have the founders or the promoters as a party to it because they are really they are the basis on which you are making the investment. And the third thing is you will have the US company as a party to it because we want to put you in the same position that you would have been had you invested in the US company directly. So the goal of the shareholders agreement here, other than our standard provisions that we have related to corporate governance, board seat, etc., is that we centralize everything at the US level. So since we have the US parent as a party to it, we ensure that all of the contractual rights are captured in the shareholders agreement. And this shareholders agreement can be used to define a whole variety of rights, right? From preemptive, veto rights, ROFR, co-sale, any other major investor rights that you might have negotiated, essentially just put you in the same position that you would have been had you invested in the US company directly. Shreya, can we go to the next slide, please? Okay, so then comes the put option part of it, right? Now, many of you might be thinking, how am I going to get a put option in the US company? What is the basis of that? How do we really know? How do we calculate what the exit proceeds are? Because, when you get shares in the India company, the cap table of the India company and the US company might not be the same. It might not really match up. How do you really put you in the same position that you would have been had you invested in the US company? So there's a very simple solution for that. What we do is on the US company's cap table, we reserve a certain number of shares for the India investor, assuming that those shares and the proceeds related to those shares would be used for the exercise of the put option. So in other words, let's say that if I were the India investor and I had to invest in the US company, then I would have received 100 shares in exchange for $100. Just a simple example. So what I end up doing is I will invest $100 in the India subsidiary and I will get my CCPS there. But in addition to that, the US company will authorize and reserve 100 shares on the US company's cap table and have my name against it. Right? So there will be a cap table entry which has my name against it. And these, of course, will be reflected across all of the documents, both in US and in India, to say that any proceeds received from those shares, which we call shadow shares, because it's not going to be issued to anybody, and it's really shadowing your investment amount here, will come back to me at the time of the exit. Of course, we decide on a number of things like what the trigger events are, what is the exact formula, etc., for the reservation of the shadow shares. But once we come up with that, this is baked across all of the documents, including the charter documents. So for the purposes of the India investor, you do have shares that have been reserved for you on the US company's cap table. Okay. Again, the goal here, I would like to repeat, is that we want to put the India investor, Shreya, you can go on to the next slide, that's fine. The goal is to put the India investor in the same position that they would have been had they invested in the US company directly. That's the goal of this entire structure. So once we reserve those shadow shares, we actually have something to peg our investment against. Now, the next question becomes the math of it, right? So how do we sort of figure out what exactly to do with those shadow shares? That's where we bring in the put option. Now, what the put option will essentially do is those 100 shares in my example before, the 100 shares that we have set aside for this investor on the US company's cap table will be the proceeds that I will receive for the exercise of my put option in India. So I have received some CCPS in India, and attached to the CCPS, I do have a put option, and the put option essentially allows me to force the US company to buy out my India company shares for proceeds that I would have received pursuant to my shadow shares. So essentially, we have this connection between the US company, the India company, the CCPS that I have in India, and the shadow shares that we have in the US. So at the time of the exit, it's very clear from my perspective what I would have received had I invested in the US company directly. So as far as your liquidation preference goes, as far as your anti-dilution goes, your conversion rights go, all of that is baked into the US company's charter, and that's tied to the shadow shares that we already have reserved for you at the US company's cap table. So that's the relationship between the put option and the shadow shares. Shreya, can we move on to the next slide? All right. So now, now we understand how this whole thing works, right? So we have a US company, we have an India company, we have an agreement between the two, which says that I invest into the subsidiary company, but I have rights in the US company and economic rights as well as control rights. Economic rights related to liquidation preference, anti-dilution, conversion, and control rights related to whatever it is that I'm able to negotiate with the investee or the portfolio company. Now, the next question becomes, okay, I invested through the shadow structure. Great, I have the shadow shares. Now, how do I actually get my exit, right? Now, in order to address that, we have worked out a few different scenarios in which you would potentially receive an exit. Now, when you talk about an exit, there are a number of ways, and of course, the documents will define what each specific aspect is. But the first thing that we can think of is a potential secondary, right? So let's say that I do find an investor who's outside of India, who's a non-resident, and I decide that I will transfer my shares to this individual, right? In that case, I can do one of two things. If the buyer is non-resident, I will transfer my shadow shares to the non-resident because they can get on the US company's cap table without any issue, without any regulatory approval, etc. So that's one option. And what I do as a consequence of that is that I force the US company to exercise the put option. Rather, I exercise the put option and I force the US company to buy me out. So in exchange for the amount that I am supposed to receive, I give up my India company shares that I have already purchased, right? So that's one option. Now, if on the other hand, I find an India buyer, for example, then I just sell my CCPS in India. So the CCPS in India goes along with the put option, along with the contractual rights that I've negotiated. And the new buyer essentially takes my place on the cap table, both on the India cap table and on the US cap table. So they get the same shadow shares that I had or whatever it is that they have purchased pursuant to my commercial agreement, and I get my exit proceeds in India. Okay, so that's one. That's the option with respect to sale of shadow shares. The second option that we think about, which is great for all of us, if we are able to participate in that, is of course an IPO or a strategic sale or a merger, right? This can come in a number of ways. It can be an acquisition, it can be a number of different things. But anytime there is a deemed liquidation event, what we call a deemed liquidation event or a liquidation event, in our SHA and SSA, we also need to find a way to ensure that we get our proceeds in India. And the way we do that is, I guess we have 4 steps that we've listed out here. The first step that I do at that time is, of course, I exercise my put option, right? So I go back to the company and say, I want to exercise my put option because there is a DLE or a liquidation event at the US company. So I have a right to do that based on the documents. So I want to exercise it. Now, what the US company does at that point is they will go through the motions of the exercise, whether it's listing on a stock exchange or it is, getting into a merger agreement, a strategic sale, whatever it is, they go through the motions. And then for the purposes of calculation, they use the shadow shares that we've set aside for you in calculating the waterfall and the liquidation and the fully diluted capitalization. So since I have exercised my put option, the proceeds that I will get pursuant to my put option are whatever I would have received had I invested in the US company directly, because I have those shadow shares set aside for me. It is on the cap table and it has my name on it. So when this, IPO happens or the deemed liquidation event happens, whatever proceeds we get pursuant to those shadow shares will come back to me. And the beauty of this is that it'll come back to me in India. So I don't have to worry about, having a bank account in the US or regulatory approvals to receive money outside of India. No, none of that. I just have to exercise my put option and I will get all of the proceeds right here in my India bank account. So I don't have to go through a regulatory approval process at all. Okay, so we have spoken about, the specifics of how the shadow structure works really. And I'm happy to address any specific questions. Anil, I know we had some specific questions that the audience had brought up before. So do we want to take that up right now?
Yeah, why don't we open it up to questions? But before we do that, because that was a lot of information packed into a few limited slides. I just want to summarize, right, what we're doing here. And there are two different sort of related components of a large part of our practice and what we are discussing here. It really starts by founders mostly making a decision. And many times if they have investors already in an Indian company, then in consultation with those investors, making a decision that for business purposes, their growth purposes, future growth purposes, they need to be a, let's say, mostly US holding company. So that's the first part of it, right? And as I mentioned earlier, at the top of the presentation, is mostly so that they can look like and smell, walk, talk like a Silicon Valley company. That also allows them to attract venture capital, private equity from global investors. It allows them to work with global customers because they're presenting a legal structure that looks, again, like any other Delaware corporation that large companies have worked with. It also allows them to retain or attract global talent because, again, they're providing an option or stock in a Delaware corporation, which developers sitting across the world or senior executives that you would want to work for your venture across the world. They understand they usually have been part of Delaware corporations and have received equity, and they understand and appreciate that. So that's the first component of it. And that in itself is a separate presentation. So we're not really delving into how we do that. The high level of that presentation or that structure is really, the goal is to create a US holding company so that all the founder stock is held in the US company, all the investors are held in the US company, and a global option plan that allows, again, for issuance of options to individual employees, consultants, advisors sitting across the world. And that US company then turns around and creates a subsidiary in India. And again, as I said, the substance of that, how we do that, depends on each circumstance. For example, if they've already raised money in an Indian company and depending on who the investors are, there are different options, and we should do a presentation on the flip part of it. But that's the first option, right? That's the first component of this analysis that we start with. Flipping or creating a new company or flipping an existing India company into a US holding company. And in all those cases, it's fairly straightforward if we do it right. And we did create that model, so we'll take credit for that. There were some questions around whether founders sitting in India can do that. So let me address that in the first component again of the flipping. We have clients, lots of clients with founders sitting in India, and the US laws have no restrictions on that require founders sitting in any part of the world from creating companies in the US. So that's one of the ways that US is very open for business. So founders could be sitting in India and incorporating these companies, running these companies from India. There is a concept called place of effective management, POEM. And so you will hear your tax advisors sort of talk about it in a draconian way. But even under Indian regulations, it's very clear that POEM does not apply to companies that have less than 50 crores in revenues, annual revenue. So when you're starting up, you're obviously not at that stage. And as we work with you, we would counsel you that once you get into that stage, you very likely would be raising money. And as part of that process, one of the founders and senior management would probably need to be moving to the US, particularly if the initial goal, as we discussed, was to create a global holding company working with customers in the US and other parts of the world. So that's the structuring and the flip. As I said, again, we can go into, and that's what would be a subject for a whole sort of full hour of discussion and back and forth. But initially, that's how the discussion starts. And many of you on the on the phone are probably talking to founders already today about investments you made in Indian companies and how to flip those over, and we can certainly help, and we have developed an expertise on that. But once you get to that stage, then we talk about, okay, how do we get the existing investors or new investors, as Ashita mentioned, that are not, for whatever reasons, able to invest directly in the US company? How do they participate in that structure, especially if they've already invested in an India company and we're flipping that over to the US company? Or if they're, AFI is registered in India, or for various reasons not investing in the US. So we came up with this new model. Basically, the concept is to reduce friction, because this new model now allows, which is the second component of this analysis, this new model allows for Indian investors to invest in the Indian company with all the rights, basically putting you in the same position as if you had invested in the US company without really making the cash investment in the US company. And it's a very creative and beautiful model, because there was again a question asked about legality of this structure. So there's nothing we are doing other than Indian investors investing and getting CCPS in an Indian company, which is legal, and having a contractual right which requires the US company to buy their shares or provide other rights in the US company, which is, again, it doesn't run afoul of any Indian FEMA regulations, but the FEMA regulations don't have any restrictions in an agreement to sell Indian shares to a US company at the time of an exit. So that's how we came up with the sort of model, and that's the analysis. I just want to summarize sort of why we are having these discussions. We have a number of questions in the audience, so maybe we can just work through the questions there. So one of the questions is, in the event that the Indian sub needs to wire money to the overseas holding company, would this tantamount to ODI? So that's a good question, but again, that's not the focus of our discussion today. The focus is investors investing in the India company. The India company, we would always recommend, should not be wiring money to the US, and in fact, no investor or founder should be wiring money in the US company. Unless, again, investors have the approval or through LRS, obviously those allow for with those limitations. But the Indian company, the subsidy should never be, there should be no need for the subsidy to wire money overseas to the holding company. In fact, the model that we create is to avoid, not just avoid, but do the exact opposite, which is raise money and capital directly in the US company as much as you can. And then in the India company, where investors are not able to invest in the US company. So hopefully that answers your question, and it may trigger ODI regulations, and in any case, it defeats the purpose of creating a US holding company or a global holding company in Delaware if you are having to transfer money from India into the US. So Ashita, there's a question for you sorry, go ahead.
Yeah, no, just one thing that I would want to add to what Anil said is that this structure, since we've brought up this concept of ODI, we've actually seen this play out in a number of different scenarios, right? One is where we have only India investors investing in a US-India subsidiary, the structure that we have. So all of the money comes into India, and they use it essentially for operational expenses, which is great. We've also seen this play out where we have non-India investors invest in the US company, India investors invest in the India company, but India investors get credit on the US company's cap table and participate in the round along with the US investor or US investors or non-India investors, just like any other investor, right? So the point about whether you need to transfer money or not is really subject to the specifics of whatever industry that company is in. But if we're talking about tech, the model we typically see is that most of the operational expenses are in India. So the point about having to transfer money should not even come up.
Yeah, and then there's a related question. I was going to go back to the structuring, but related question from Chirag Tinglani. So it's the fellow Sindhi, so I have to give him priority, I guess. But then it's related because the question is whether this model is only applicable if the company has planned use of funds in India. I would say not just this model, but in large cases, almost all cases, the whole model is that although we are creating a US holding company for the purposes of all the good reasons I mentioned, nothing changes on the ground in India, right? The founders are in most cases living in India, working in India. The engineering team is still being developed, and everything sort of is still being developed in India. So the money the large allocation of the capital that you raise, not just on day one, but as you continue to raise, will still be spent in India. So whether you raise capital into a US holding company and then flow it into India, or raise money into an India company and use that for your similar sort of product development and sales and everything else that you would otherwise do in India, that analysis doesn't change, right? This model is meant for covering an instance where the operations are largely and continue to be largely in India, but the capital raising and the legal structure for good reason, again, is required to be a US holding company. There's a question about a flip structure where Indian holding company with a US subsidiary. Is that feasible? Ashita, do you want to take that?
Indian holding company with a US subsidiary, is it? I don't
Yes.
see the question, but what would the purpose of that be? I mean, if you already have an Indian holding company, I'm assuming that all of the value creation is here and the investment is coming here. So there's no question of having to invest in the subsidiary, right? The idea is that the structure is for allows Indian investors to invest in US India structures without having to actually go through the approval process. So you just invest in the India company so that you don't get any SEBI approval, you don't need any RBI approval, go through LRS caps, none of those things. But you are treated the same way as you would have been treated had you invested in the US company directly, right? So we're essentially allowing you to skip one part of it just because of the fact that there are caps and that won't allow you to do that.
Yeah, the short answer of that is yes. I mean, an Indian company can always create a subsidiary and structure it. Again, it's a completely different sort of the exact opposite goals, which is that it's really primarily an Indian company that continues to run and operate a business largely focused in India, and perhaps has needs to set up in the US or other parts of the world as more marketing than product development and creating a global holding company. So that very different sort of model and different goals in terms of structuring those. There's a question, Ashita, about a secondary sale to a non-resident. The overseas company holdco would do a buyback of the Indian shares of the existing investors. So I guess you can sort of go into the details of how that would work.
Yeah, and I think that also relates to another question that Ashok Anantkrishnan has asked here. So I'll combine the two together. So you're right, if there is a secondary sale and the investor is outside of India, the way it would work is that the non-India investor would pay the proceeds to the US company, and the US company would use those proceeds to do two things. One is allocate those shadow shares to that non-India investor who's putting in the money, and two, use those proceeds to exercise the put option in India. So all of this will happen simultaneously. If the non-India investor, let's say, buys it for, in that example that I gave you, I invested $100 and I got shares in the US company. Let's say I'm able to sell it for $150. Now, the US company is going to sell those shadow shares to that new investor. Let's say Anil, in this case, if he's going to buy the shares from me, Anil is going to pay $150 to that US company. The US company will issue those shadow shares that they had reserved for me all along in Anil's name. And that $150 will come to me in India towards the exercise of my put option. So I give up my CCPS in India through the exercise of my put option, and the US company pays me $150. And I think Ashok also had a question about lower value to the new round. I think secondary transactions are irrelevant of what the new round price is, right? I mean, for the purposes of US laws, at least, you can do a secondary at whatever price you want. There's a tax consequence to this, which you'll have to bear anyway. So it doesn't matter for the purposes of exercising this put option.
Yeah, and going back to the earlier question on the secondary sale to a non-resident, we haven't done this yet, but it's something that we are looking at also, which is an option where instead of the process that Ashita mentioned, you could also, as a holder of the CCPS and the put option right, you could actually sell that directly to a non-resident. So for example, a US investor could buy your CCPS in the India company, and with that have the put option, and therefore exercise that put option and then convert that CCPS into US company shares, because they would not have such restrictions. So that's another option we could have, where you as an investor are still getting the same price, except you're selling your CCPS directly to, for example, a US investor. And again, none of that is prohibited under current Indian regulations.
Yeah, I think the beauty of this is that it's really flexible, right? All that we are doing is that we have contractual rights that are in place, and both the US company and the India company are party to this agreement. So they are obligated to follow through with their contract. Of course, we have indemnification. We have a bunch of other things that are also built in, just like any other good legal counsel will advise you to get all of that stuff in place. But it's really no different from any VC investment that you are making, right, in your portfolio companies, because all of that is a contractual right. So you will be protected both in terms of the economic rights that you need to get, your liquidation preference, your anti-dilution, etc., and in terms of the contractual rights that you negotiate.
There's a question from Ashok about whether it can be applied to a Singapore company with Indian subsidiary. I mean, the short answer is yes, because Singapore, again, is a non-India entity, so similar structures. I would just, because we are in Silicon Valley and we drink the Kool-Aid, I would just say first evaluate why you want to be a Singapore company, a holding company. In most cases, it's driven by maybe not just the best advice, but if you're a founder thinking about a Singapore company, the threshold question should be, is that the right jurisdiction for growing your business? And what are the sort of main purpose of your and the target audience, market, customers, investors, potential exit opportunities? Once you make that decision, similar structures can absolutely be used for Singapore holding company as well. There's another question from Xfinity Ventures. I think that was asked earlier about routing money from India to US, and it is a good question. I want to delve sort of somewhat more substantively into it. These are models where the assumption is that yes, the value creation is happening in the US mostly. And in light of that, the IP is being held in the US as part of a service arrangement so that all the work done in India is assigned to the US. And it's a good and very valid question, because if you're doing that, but the money is in India, then what is the US company paying for? And again, in almost all cases, it turns out that the company that we are looking at is raising money from India investors, maybe a smaller portion from the India investors under this structure, and a much larger portion of investments from the US or global investors directly in the US company. So that is the money that's transferred or used to transfer into the India company to show what you call the value creation and the sort of payment for the services for development of IP in India. So you're right, the maximum spend should happen not in the US necessarily, but from the US into the India company through what's called a master services agreement. There's a question from Vikas on, and this goes into the first part of the discussion, right? We were saying there are two components. One is structuring India, US. So if you're a founder looking to create a structure where you can raise money from US investors, which is, absolutely, you should be thinking about very early on. If your market is global and your potential investors are coming from across, that's the right answer. You create a US holding company. And as we mentioned earlier, the US holding company will have basically concentrate and own all the founder stock, your option pool, your global option plan, all your investors, your intellectual property, all of that will be concentrated in the US holding company. So, and the US holding company in turn will create a subsidiary in India. And the subsidiary in India will have, if you're a founder sitting in India, you would be employed by the Indian subsidiary. All the work you do in India will be assigned to the Indian subsidiary as part of your employment. And that IP that you develop along with all the other employees in India, all of that will be assigned to the US company as part of this master services agreement. And these are very easy structures to put together. So these are in fact, I would argue, cheaper than even creating an India company and the compliances that go along, the ongoing compliance that go along with Indian companies. So that's just the right structure, Vikas, where you have a US holding company with a subsidiary in India. And then the funds you raise money from US investors and a large amount of funds flow into India. And if there's any politicians or policymakers on this call, I want to address the very underlying sort of question and concern that comes up. It's actually great for Indian founders and Indian economy generally, where founders sitting in India are able to access global capital into a structure that's created as a Delaware holding company, because there's a lot of patriotism and we are as Indian as everybody else. But this is good for India, because imagine that, billions, tens and hundreds of billions of dollars are being raised in Delaware companies. Almost all of that is flowing back into India to employ people, develop IP and pay taxes in India and generate sort of the economy and the ecosystem in India and build products for the global world. So, I mean, I would say, I always argue that it's actually good for India. This is not a forum for that argument, but I want to highlight that if you think about the underlying impact, not just the fact that it's a holding company or not holding company in India outside, the underlying impact is actually great for India, because Indian founders sitting can create global products and access capital that comes back to hire hundreds and thousands of other engineers and other talented folks in India. Ashita, do you want to take the question from Sania?
Yeah, absolutely, Sanaya. So these rights are enforceable because, again, like I said, these are contractual rights that we are providing to you. And as far as your economic rights are concerned, that's built into the charter via the shadow shares that have already been set aside for you at the US company's cap table. So I don't see an issue with enforceability specifically. Now, to go into a little bit more detail, which of course is very fact specific and client specific, sometimes we have the agreements governed by Indian law because investors feel that it's better to have this governed by Indian law. You want to go to Indian courts if at all we need to challenge this. And we've also done it on the other side, right, where it's governed by US law. So I don't see a problem with enforceability of this. I'll also address another question that came to us before the call here. In fact, one of the investors that we have worked with actually went through an entire cycle here. So they invested via the shadow structure. The company went on to raise multiple rounds of funding from non-India investors, and this investor did not participate. They didn't really top up. So they continued to hold their investment in the India entity. And at the end of, I don't know, 5 years or something, they sold. So they received the proceeds in India via the exercise of this put option. So we've seen this structure go through an entire life cycle. I mean, right from the stage where people were apprehensive about it, they didn't know if this would work, this is a new structure that has come up, to now we are actually representing banks, we're representing some of the largest Indian funds, we're representing AIFs, HNIs, people who want to participate in a round where it's full of non-India investors. There's just one angel. Sometimes there are just, there's one Indian institutional investor who wants to participate. So we've literally seen this in a whole variety of options, right? And I've never seen enforceability been an issue with any of this.
Yeah, again, I want to reiterate, what we are doing here, right? Which is, and it was meant to create, sort of remove, not create friction in all the entire process. What we are doing is providing a mechanism for Indian investors to invest and buy CCPS in an Indian company. So there's no round tripping to the other question. There's no round tripping there because there's no money going from your Indian account to outside India, right? And then all we are doing is also adding contractual rights in US, in the US company, and those are enforceable under Delaware laws because this is by contract. And because you are investing in the subsidiary of the US company, Delaware courts have held that they automatically will rule that benefits the parent company. So in terms of, there's sometimes questions on what is the consideration, why is the US company entering into and providing these rights? But the US company is providing these rights because the investment you're making in the subsidiary is automatically deemed to have benefited the US parent company because of that investment.
And that's exactly how, to Nirav's question, that's the flow of funds essentially comes from the buyer in that example that we spoke about, comes to the US company. The US company allots those shadow shares that have been reserved for me on the US company's cap table. Now, Anil wants to be on the cap table in that example. So Anil just takes over those shares. Now, everything with respect to those shares have already been negotiated, right? Because we already have that as part of our agreements. And to add a little bit more sort of credibility and give the investors more comfort, we actually include this in the US level agreements as well. So imagine a situation where along with me, who's an Indian investor, we have 5 other US investors, right? So I don't want to be sidelined because I'm not a shareholder at the US company level. So we bake all of the rights that we have asked for or we have negotiated into the US company documents so that tomorrow when there is a secondary, when Anil takes over my shares in that example, he gets all of these rights right away because it's already baked into it. Right. And in terms of the flow that we are talking about, Anil pays money to the US entity. The US entity uses those funds that it's received from the buyer to buy out my CCPS in India. So since I have CCPS in India and I have a put option associated with that CCPS, I exercise the put option. And in order to enforce that put option or in order to give light to that put option, the US company uses the money from the buyer to pay me. So essentially the funds flow through the company. That's one option. And the other option, like we said, is that the buyer can pay to me directly, right? If that's better, it's flexible. We can do both. The buyer can buy the shares from me. And then in the CCPS or in the shareholders agreement, we also have, we have 2 options, right? One is we have a swap mechanism, if they need a regulatory approval and let's say tomorrow DIPP comes back and says, okay, you can do a swap without an issue, then that's always an option. You can always swap this out. The second option is, of course, they buy the CCPS, they exercise their put option, and they get those shares that are reserved in the US company level. The second one is a little bit more convoluted because it has to come through this, but that is an option as well. Sometimes, based on who the buyer is or what their regulatory scheme looks like, we could choose that as well.
And there's a question I think we've addressed, but just to be sure, Rohit has asked about whether angel funds, Cat 1 AIFs can participate via the structure, and the short answer is yes. And as we explained, no overseas investment approval should be required because you're not doing anything. You're not making an overseas investment. You're making the investment directly in an Indian company with the CCPS. Balaji again has asked a question: if other investors are in the US subsidiary at the end use of funds are in US, but the holding company is in India, how do we structure this? I mean, the short answer is you have to really look at why is the holding company in India. If everything's happening in the US and investors are coming in the US, you may want to, I would strongly suggest that you think about restructuring, if you're already an India holding company, restructuring the holding company to be a US holding company. Sanaya, I mean, Ashita, do you want to take the Sanaya's question? Are there any scenarios in which the structure can fall apart?
Honestly,
if you don't work with us.
Yeah, but honestly, I think if the structure is actually designed right and you have things captured. So I'll tell you the most challenging part about the structure is really ensuring that everything is properly documented, right? And ensuring that whatever has been commercially agreed upon is actually reflected across the whole universe of documents here. That's one. The second thing is, of course, making sure that everybody is aware of what they're getting into, right? Commercially, you need to understand that this is what you're getting into. You're putting in money, you're getting shares in the India company, and you get a put option along with some contractual rights in the US company. And the founders or the promoters need to understand that you will be on the US company's cap table for the purposes of the waterfall, calculating the waterfall at the time of an exit, right? As long as that is commercially clear, it's pretty simple, and I use simple obviously loosely here, but simple to put together the structure for us. So when you say, are there any scenarios where this falls apart? There are several moving pieces to the puzzle here because there is a US part of it that we'll need to take care of. There's an India part of it because you'll have to do a full CCPS round here, which is a private placement along with all of the applicable compliances, secretarial, all of that stuff in India. Plus the same thing has to happen in the US. And then we have to connect all of this together, right? So you just really need to work with the right people to ensure that this whole structure can be put in place.
Yeah, and Ashok has a very important question. And I'll say that, one of the reasons we do these presentations, besides the obvious reason of soliciting business, and sharing information, is to also learn. And we spend a lot of time coming up with these scenarios and trying to address these scenarios. But Ashok, what you mentioned is a very good question and unique question. I will not give you a direct answer because I will need to look at it. But the reason we've never had to do this is because we've typically always had investments coming in the US along with the shadow structure in India. So we're always evaluating from CFIUS. So the question is for others who may not be able to see it, if we are issuing shadow shares in India and the investments in India company, does the investor and in fact the company have to consider CFIUS related issues? And the reason we have not had to do that is because, as I was saying, the investments have been accompanied concurrently by investments in the US. So we are looking at CFIUS related issues in any case. But the lawyer in me would tell you that it has to be, right? I mean, the US laws would not be so loosely structured that you can get around CFIUS by investing in a subsidiary when the controlling entity is the beneficiary of that investment. So I don't have the right answer. Like, I have not opened up the book to give you the answer, but I would say my instinct would be to say yes, but I'm happy to come back with the confirmed answer after researching the law. But I can't imagine the laws would be so loosely structured that they would allow for investment, for example, by, in this case, a Russian company, in an Indian Russian investor in an India company and getting away from because it's an investment not in a US company. So if it's controlled in any way and this is part of the same structure, I would expect that CFIUS would apply.
So I think Abhiram has another question. Is SEBI approval required when an AIF exercises put option to acquire shares in the US entity? So let me take a step back here, right? Now, the goal of exercising your put option is to ensure that you get proceeds in the India company, right? So we want to make sure that your put option is exercised at the time when one of two things: either there is an exit at the US level, so like we spoke about, there's a liquidation event, there's a merger, there's an IPO, any of those things, or second is that there's a secondary sale that is potentially happening. Now, if there is a secondary sale that is happening, you probably don't need to acquire shares in the US company, right? You can just get the proceeds here. That's the whole purpose of the put option, is that you don't need to acquire shares in the US company. Because the moment you acquire shares in a US company, in this structure especially, the SEBI approval will potentially kick in at that point of time, right? Whether you acquire it now or you acquire it later, SEBI doesn't look at that, right? It says that you do need an approval at the time that you acquire shares in the US company, and it's always a prior approval. It can't be a later approval. So I'm not sure that, the goal of this whole structure is to ensure that you don't have to get shares in the US company. Because if you could, then, you would do that directly, right? You wouldn't have to go through this process itself. And one more thing I also want to point out there is, in the eventuality, and some investors have asked us this when we've invested, is, in the event that share swap does become a lot easier and a lot faster than it currently is right now, where you don't have to wait, endlessly, and potentially we could do it. We've actually built that into it, right? So there is an option for you to be able to swap your shares. Tomorrow, if the DIPP says, okay, we'll look at this in 15 days and give you an approval, then great, maybe you can go ahead and do that. So the way these, the structure is created is two things. One is to put you in the same position as you would have been had you invested in the US company directly. And the second is it gives you a lot of flexibility. Now, when I say flexibility, I say that because each deal is different, as you already know. It depends on what the terms are. It depends on what your specific regulations are. It depends on what the promoters have promised, etc. So if you are in a situation where you say, okay, I'm buying this through one fund today, and I do know that I have to transfer it to another fund tomorrow because this life cycle is almost done, whatever may be your reasons, we can actually build that into the documents and say, okay, this is something that we will create just for you. Right. So it is possible to do that. And again, our goal is to ensure that we don't have to acquire shares in the US entity.
And to reiterate what Ashita was saying, and I think this brings up an interesting sort of follow-up comment, and Ashita has addressed that already, but startup land is always urgent, right? I mean, everything needs to be done right away. So this is a good structure also, which would allow you as an AIF, to Abhiram's question, to invest and get that going. If your SEBI, so for example, if you're thinking of getting a SEBI approval and it might take 2-3 months for whatever reasons, you're getting everything together, this would allow you to get sort of the investment into the India company, get your SEBI approval, and then exercise your put option, and again, be in the same position as if you invested on day one, while keeping your relationship with and the opportunity to invest with the founders, because you were able to invest on day one instead of waiting for month 3. Things change in 3 months, right? As you know, and that investment that you're looking to make today you could lose that investment, the valuation could go up, lots of other things could happen. So again, this allows you to make the investment right away, get SEBI approval, and then exercise your put option and be in the same position. I don't see any new questions, and we do have 5 minutes remaining. So Sunita, Shreya, do you have anything else that you'd like us to touch upon? Or obviously the audience, if you have any other remaining questions, please feel free to ask now. Okay, so I think we can end the session. I would end the session by, again, thanking everyone for joining us. I know it's middle of the week, middle of the day, middle of a busy week for all of you. So to take the time out to join us for this presentation, we obviously love doing this. That's why we do it. And it's great business for us, to be sure. But we are very excited about the role we can play in facilitating the cross-border India-US investments. And we'd love to hear from you on how we can help you in your future investments and any questions that you have in this route. It is complicated. We spent a lot of time to streamline and simplify it, but there's always new questions and new issues that we have to address, and we remain committed to work with you in addressing those. Ashita, do you have any final words?
No, I think you should really, if you haven't already started looking at non-India companies because of the regulatory approvals, this is the right time. I don't think I've seen as much steam with this structure that we have in the last 2 years, for sure. As I was mentioning, we have represented a whole gamut of investors who have adopted this structure, some of whom have come back a second time to do it. And we've had, which we really consider a personal success, is we've had at least 3 banks who have invested in this structure. And banks are probably the last people to take on any new structure and anything that's unconventional. So that's actually been very good for us.
Thank you, everyone. Have a good week. Bye.
Bye.